For trade secrets, the definition of a trade secret is confidential or proprietary information that is not generally known or ascertainable, derives independent economic value from not being generally known, and is the subject of reasonable efforts by the owner to preserve the secrecy of that information. Trade secrets includes information that may not be protected by other types of IP. So for example, recipes, we saw that for copyrights, lists of ingredients are not copyrightable, but the recipe may be retained as a trade secret. It would cover processes, the location of oil wells, and compilations of information. Trade secrets are governed by state law, where each state has implemented its version of the Model Uniform Trade Secrets Act, as well as federal law, specifically the Defend Trade Secrets Act. And the important thing to note here is that those legal systems coexist. So the Defend Trade Secrets Act did not preempt the Uniform Trade Secrets Act. Turning to the issues in transacting with trademarks. The primary exposure here is that trade secrets that were acquired by improper means by your target. So for example, if your target is a technology company that poached employees from its largest competitor and encouraged them to take a lot of documents on their way out, by acquiring that tech company, you're walking into a trade secret misappropriation lawsuit. You also want to be mindful of the ability to reverse engineer a product that's developed by that target that contains the trade secret. And this would be reverse engineering by proper means. So if anybody could deduce what the trade secret is from taking apart the product, you'll lose your trade secret protection. So you may want to consider patents, or you may want to consider not following through with the acquisition, since it may allow many competitors to enter the market. And the last point on exposure is you want to make sure that your target has adequate policies and agreements to preserve the secrecy of the trade secrets. And so for agreements, you'd be looking at non-disclosure agreements or even provisions in other agreements with consultants, contractors, employees, basically anyone who would have access to the trade secrets. Unfortunately, there are limitations on diligencing trade secrets without risking losing rights in those trade secrets. So if it's, for example, a competitive auction process and there are a number of bidders, if the trade secrets are disclosed to each of those bidders, even if it's subject to an NDA, if too many people know the trade secret, have you really kept it secret? And so you may gut the value of the company by disclosing it during diligence. You also want to consider whether trade secrets can actually exist independently of the employees or contractors that develop them or use them. And so even if you may only be contemplating acquiring trade secrets as the primary asset, you may also want to consider the employees and contractors to come over across in an asset purchase, or have some lock-in for some key employees that know the trade secrets. Tech transfers could be an alternative to that, and so that would be putting in the transaction agreement itself an obligation on the part of the seller to teach the buyer how to use the trade secrets post-closing. Turning to the second segment, the structures for transacting and commercializing IP and the issues that arise from those structures.